Good morning, everybody. I'd like to start as well by thanking Commissioner Dervishi and his staff. I just think they've been fantastic, the way they've looked after us in this conference. So wherever you are, Commissioner, thank you, and thank you, all your staff. 10 years ago, on the 6th of November, you know what they haven't done? They didn't explain to me I had this button. Well. Excuse me, I'm just learning the technology. 10 years ago, on the 6th of November, this conference embraced accountability in the Madrid resolution on international standards for the protection of privacy. This did not happen overnight. It was the culmination of meetings that lasted over about a year. And the original idea was that accountability was a means of facilitating international transfers. And as we know, this is still a very important element of accountability, if you look at APEC and you look at BCRs and so on. But accountability over the course of these meetings was transformed. And it was transformed from a principle relating to international transfers to a self-standing general principle. And here it is in Article 11 of the Madrid resolution. If I paraphrase it, it says the data controller shall actively develop compliance and shall demonstrate and be able to demonstrate that compliance to data subjects and regulators. So I want to use this time together to talk about why this text is so important on this 10-year anniversary. What is accountability and how do we think we can get there? And maybe to establish my credentials, I could just talk about my own journey to accountability. As head of the EDPS Secretariat, I was both a regulator and a data controller. And you can imagine that I tried to make sure that the EDPS was very compliant. You know, we had our notifications. If anything happened, we tried to react to it nicely. But I didn't know what accountability meant, and I had to learn, and I actually had what you might call a eureka moment, or a Damascus moment. But my eureka moment, it wasn't in the bath like Archimedes, it wasn't on the road to Damascus like St. Paul, it was on the train to Paris for a meeting with chief privacy officers. And on the way to Paris, I actually read a small, very thin handbook on accountability. And it set out what accountability actually entails. And by the time I got to Paris, bing, I had understood what accountability was. And in fact, it wasn't a very comfortable feeling because I thought, oh my goodness, I hope these people don't ask me what we're doing to be accountable. But anyway, as you know, privacy officers are a very sweet and trusting group of people. And I escaped from this conference unscathed and came back to Brussels and spent at least 2 years then embarking on trying to make the EDPS a fully accountable organization. Now, what do we mean by the word accountability? It's an amorphous word. It comes from an Anglo-Saxon, keeping accounts. And you can see it in some languages in the same way, a nuance of financial accountability or paying the bills. Rechenschaftspflicht in German and Rozliczalność in Polish. Some languages just use the word responsibility, la responsabilité in French. But this doesn't do it for me because that word is too close to compliance for me and too close to legal liability for non-compliance. So accountability for me is different. And where do I find the language that gives me accountability? I think we find it in Spanish from Colombia and from Spain. La responsabilidad proactiva from Spain, actively developing compliance, and la responsabilidad demostrada from Colombia, being able to demonstrate compliance and put them together, and you have actively developing and being able to demonstrate compliance. When it comes down to it, your language may not have a good word for accountability. If it doesn't, then try and remember Romeo and Juliet. You remember that Romeo had a certain problem with the fact that Juliet's surname was a difficult thing for her. And so we have this expression, a rose by any other name would smell as sweet. So I'd like you, if you don't have a nice word for accountability, to imagine it as a rose which is lovely to behold, which has wonderful effects, but which has very sharp thorns. Now, if accountability is a rose, it is flowering across the world, in time and in space. If we go back to the OECD guidelines in 1980, we can see the term accountability. But there, it actually just meant the old meaning of compliance with legal obligations. And as I realized on the train to Paris, compliance is not enough. It is not accountability. It is a fundamental shift in approach. Accountability has moved data protection from being an adjective to a verb. What we had was an adjective, a definition. Who is the person responsible? Now we have a verb, an activity. What is the responsible person doing? And the first legislation on accountability in this sense was Canada, was the PIPEDA in the year 2000. And that was followed by the APEC privacy framework in 2005, which actually implemented accountability mechanism in the APEC cross-border privacy rules a bit later on. But things really started moving from 2008 onwards. There was the Global Accountability Dialogue, a series of meetings where regulators, organizations, and civil society representatives cooperated and exchanged ideas. And in my view, the direct result of this was the Madrid resolution and the clause that we've just seen. And as well as that, it resulted in the opinion of the Article 29 Working Party in 2010. And what was significant about this is you saw the Working Party asking the European Commission, please include an accountability clause in the GDPR. And that was one of our successes in lobbying the Commission, was to get this clause into the GDPR. But there was something missing. And in 2012, 3 of the Canadian privacy commissioners realized that it's not enough to have the legislation. You have to explain it. And they provided guidance on getting accountability right with a privacy management program. And this was a crucial step because without guidance, most organizations do not know what to do in practice to be accountable. And then on, from 2013, guidance on accountability has been adopted by regulators across the world. Hong Kong in 2013, Colombia and Australia in 2015, and the Philippines and Singapore in 2018. And over the same period, you've had an increasing number of countries and international organizations adopting accountability into their national laws. Mexico adopted accountability. They had the word in their 2010 law, and they explained it in their regulations in 2011. The OECD updated their guidelines in 2013, and we have a whole clause, a part 3, on implementing accountability. In 2016, the EU enshrined the accountability principle in Article 24 of the GDPR. And Peter Hustings says that Article 24 is his favorite article of the GDPR. I think it's mine too, to be honest. And it is arguably, according to Peter, the most central provision of this regulation. In 2017, Guernsey, which has an adequacy finding from the EU, updated its data protection law so as to be in line with the GDPR and to keep its adequacy finding, including the accountability principle. And there is a message there for the other adequacy countries that they should seriously think about adopting accountability too, if they want to keep their adequacy finding. And in 2018, perhaps after listening to the last 2 days of the conference, most important, the accountability principle was enshrined by the Council of Europe in Article 10 of Convention 108 plus. And that means that signatories to this convention will have to implement the principle of accountability. Most recently, 2019, we see that Brazil, in its general data protection law, has included the principle of accountability. And I learned yesterday, I think it was, from the Ghana Data Protection Commissioner, Patricia Poku, that African regulators now are looking to accountability and not merely to compliance from data controllers. Now, this history illustrates two important points. Firstly, accountability is a global standard. We have it. It is there. Colleagues across the world are used to the EU telling them that we are the gold standard, we're the bee's knees, everybody should respectfully listen to us. But we cannot say this about accountability. It is there. The GDPR came late to the party, and we are learning too. And secondly, accountability needs both legislation and explanation. It must be in the law, and it must be backed up by effective guidance. It is not self-regulation. Marty Abrams, who we'll hear from soon, has blogged that the basic principle of accountability must be embraced by law, with regulators able to generate enforceable guidance related to the principle. And we really have to talk about accountability today because there is a lot to be done. The GPEN 2018 data sweep looked at how organizations are implementing accountability, and it concluded they should be doing more to achieve privacy accountability. And the IAP EY report in 2018 found that more than half, 56% of organizations subject to the GDPR said they are far from compliance or will never comply. So there is a big challenge there. And part of responding to that challenge is to see accountability as the solution, not as part of the problem. The new data protection legislation that we're seeing being developed, you will always see it criticized as a step too far, too expensive, obligations and procedures which are too onerous. But if you're an accountable controller, you will understand why these things are here, and it will fall into place. So how do you get to be accountable? One way is to see accountability as a toolbox, full of useful tools. If you take the GDPR as an example, then you can see a number of accountability mechanisms, which I'm not going to discuss now because we could spend the whole day on it. I just want you to see them. But these are not legal requirements only. They represent best practice. And too many people think that accountability and these accountability mechanisms in the toolbox are just extra obligations. But we should see them as helpful tools rather than extra obligations, and as part of the solution rather than part of the problem. And if you're a controller and you use these tools, you will have carried out the core of your legal obligations. Now, another way of looking at accountability is as a philosophy of being a responsible and ethical steward of personal information. You need an aha moment. I had mine on the train to Paris. And there are various ways to get there. It can come to top management if they get the right message. An awful lot of managers realize that privacy may be an extra burden, but it is something that has to be done. And Tim Cook was like that. And a few years ago, he was at the same meeting as Giovanni Buttarelli. And he invited Giovanni to a meeting. They scheduled a whole 15 minutes, because, of course, Tim Cook is a very busy man. And Giovanni was invited in. Tim Cook said something like, well, could you just explain to me all this privacy stuff? And Giovanni responded with a question. And he responded by saying, do you know the name of your chief privacy officer? And they went on from there. Giovanni came out of the meeting over an hour later, and Tim Cook had had his aha moment. The path to enlightenment can also come from team members. Maybe when they remind managers that they are processing the personal information of fellow human beings. In Axiom, a few years ago, the analytics team developed a model of 10,000 audience propensities. I don't know precisely what those are, but I think they're snippets of information about us. And these included scores for sensitive personal information, such as erectile dysfunction and vaginal itch. And the leadership team was discussing whether they could use these scores, or would it be too invasive? And one member of the team had come prepared with the actual scores on these topics for each of the individuals in the room. And once they were confronted with this very personal information about themselves, the leadership team realized that these types of scores were too sensitive to be made available as a product to customers. So this story tells us how important colleagues can be for accountability, and it reminds us that modern data processing can be very, very personal, and managers need to take it very, very personally. Now, when you've had the aha moment, what do you do? In 2012, the Canadian commissioners pointed out that accountability is what you do because it's the first amongst the first fair information principles. It is the means by which organizations are expected to give life to the rest of the information principles. And I'd like to just talk about 4 points this morning. Firstly, and primordially, you have to have the commitment of top management of the organization. Top management have to take data protection seriously. To be honest, they have to manage risks. And what they put in place has to ensure that all management are committed and staff are committed. Otherwise, you'll have a nice-sounding privacy policy which will be a hollow shell. Once you've got that, then you need to put your privacy management program into place. You don't need to do everything at once. You can prioritize, handle the issues step by step, which is how we did it. It's a process, a responsibility that requires constant care and attention. And we'll be discussing many of the elements of a privacy management program in the panels today. So I'd just like to underline what I think are the two most important elements of such a program. Firstly, the appointment of a data protection privacy professional. This is the person or the team that will assure the internal implementation of the privacy management program. In 2010, the Article 29 Working Party said that the DPO, the Data Protection Officer, is the cornerstone of accountability. This year in Stockholm, the Nordic data protection authorities recognized the importance of accountability and committed themselves to supporting DPOs and carrying out their work. And the second thing I'd underline, and this is a tough one because many of us here might say, oh, privacy by design should be number 2, and I have some sympathy for that. But I would put transparency as the second most important thing about accountability. It goes to the heart of the concept about demonstrating what you do, and demonstrating to data subjects, to regulators, and the public. And the proof is that if you get transparency wrong, you may have serious problems. For example, what if Google, Amazon, Facebook, Apple, in terms of managing their smart assistants that we know and love so much, what if they'd announced they wanted to make recordings and to use human beings to check those recordings for quality purposes? What if they'd said openly, we're going to do this, we're going to have a clear framework of what we're going to do with safeguards, and we would like volunteers to do it? We would not have had the scandals this summer. We wouldn't have the articles on why are you snooping on me, or the article a couple of weeks ago in The Observer, Alexa, are you invading my privacy? So it's clear there are advantages to accountability. So let me talk about those for a moment and about the two target groups that I have in mind with these advantages. And those are, you may assume, of course, controllers, but they're also regulators, because regulators have a job to do and have benefits from accountability. So if I look at the advantages for regulators first, big advantage of accountability for a regulator is that it can offer low-hanging fruit when you're doing your work. The first thing the regulator in an accountability system does is to ask to see the accountability records. And with those, you can make a distinction between an accountable organization and an organization that is clearly not accountable, has no clear overview of what it's doing. And you can prioritize your work on the second type of organization. There are huge savings in accountability if you can get it going because, for example, it minimizes over-reporting of data breaches because accountable organizations know when not to notify. The researchers seems to have found that about 100% of data breaches is the figure that most people assume should be notified. So if there's a data breach, notify the regulator. Whereas if an organization has got good incident risk preparation and assessment, it only actually needs to notify about 10% of data breaches. So this is a huge saving both for regulators and for organizations. And thirdly, as we'll be discussing in the next panel, I think, it can work as a bridge between jurisdictions. Andrea Jelinek has said that accountability can help us bridge jurisdictional and legal differences by creating interoperability. It can facilitate transnational investigations by providing a more uniform environment, an environment based on mutually agreed or commonly accepted privacy and implementation standards. And I'd add to that, it's an advantage, actually, I'm going to come to organizations in a moment, but Paul Breitbart has pointed out that accountability works like an electric converter plug. It means if you're an accountable organization working in multiple jurisdictions, you'll have the ability to fit into each jurisdiction. But as many organizations already know, this means a new type of work for regulators, an investment of resources in accountability, and we know that resources are limited, but I think accountability satisfies the 80-20 principle. You put in 20% of your resources and you will get a return of 80% comeback. So regulators have to provide support where it is needed, and whether you're small or whether you're big. So at one end of the extreme, we have Guernsey, which has drop-in sessions for controllers every other Wednesday morning, and these have proved to be remarkably successful. So they take time, but it is helping controllers to get to grips with the new legislation. And then we have a large authority like Spain. You have what they call the Facilita software tool, which is designed to help SMEs to be compliant, to be accountable. And I think there's something nice about the fact that today, 10 years after the Madrid resolution, it is the Madrid Data Protection Authority that on Monday actually won the regulator's accountability prize. So bravo Madrid, it's a great software, and apparently you can download it and use it off their website. So regulators have a lot to do to provide leadership, support, and guidance. What about organizations? The first and major advantage is accountability prepares you for the known unknowns. This is one of the things I realized on my road to Paris, my train to Paris. There will be subject access requests. There will be data breaches, complaints, investigations. But the GPEN data sweep in 2018 found that a number of organizations had no processes in place to deal with the complaints and queries from the data subjects, and that they were not equipped to handle data security incidents appropriately. So accountability gives you this. When the regulator calls, then there will be a documented privacy policy to show them. Bojana Bellamy will tell you that regulators should take demonstrated accountability into account when carrying out investigations and enforcement. And you can see this approach in the Singapore authorities' Model Artificial Intelligence Governance Framework of 2018. And what that says is, and I'm paraphrasing, I've got the wording here, but what it actually says is, adopting this framework does not mean you have to be compliant. You still have to be compliant. But it will help to demonstrate that you have implemented the necessary accountability-based practices. And Marty Abrams would argue that you could even have a safe harbor one day in law. So the AIF model accountability law says that an accountable organization that has satisfied the requirements of a privacy impact assessment or a code of conduct shall not be subject to civil penalties. Thirdly, accountability is a competitive advantage, and we've been hearing something about that during this conference. A strong privacy policy on the website means consumer trust and a strong reputation. And the EDPS has been arguing for years that accountable firms should gain a competitive advantage from being fully accountable. And then last but not least, we are faced now with this game changer of artificial intelligence. And accountability provides us with the methodology for dealing with it. The accountability toolbox is there. The mechanisms are there. And they would allow controllers to respect privacy and develop AI at the same time. 3 examples. Risk assessment. Automated decision-making will always trigger, with significant effects on data subjects, will always trigger a data protection impact assessment under the GDPR. Privacy by design, or privacy by default. This means that an accountable organization will design in, where it's appropriate, meaningful human review. And thirdly, transparency, which is, again, really important. An accountable organization will provide information on the values that are underpinning these automated decisions. That's the positive side of accountability. What about when things go wrong? And believe me, things can go wrong. We should have no illusions. Whatever can go wrong will go wrong. And for controllers like me, like I used to be, who want to do the right thing, accountability means preparing in advance, organizing the security, putting all the procedures into place. And if you're such an organization, you'll be in a good place if things go wrong and the regulator calls. But if you fail to plan, you plan to fail. When you don't plan and something goes wrong, you may find yourself sanctioned and even fined. And this is what Marriott and British Airways have found out this year, courtesy of the ICO in Manchester. Secondly, I think we have to see administrative fines as supporting accountability. The GDPR uses the same wording in the provisions on accountability mechanisms, and fines. It talks about the risks of varying likelihood and severity for the rights and freedoms of natural persons. If you're accountable, you've taken these risks into account. If not, you risk being fined. And the GDPR specifies that fines may be imposed for failure to implement the accountability mechanisms. And we shouldn't assume that these are too abstract. For example, in June of this year, the Romanian Data Protection Authority fined an Italian bank the equivalent of 130,000 euros for failure to implement privacy by design. So these are the problems for organizations that fail to be accountable. What about the organizations that actually don't want to be accountable, that resist compliance? A couple of comments. You are not accountable if you hide behind consent. You say one thing in your PR and your privacy policy, but you do something else in the research lab and on your website. You're not accountable if you treat the risk of non-compliance as a business risk to be factored into your turnover forecasts. And an accountability law, a rose with thorns, will have 3 consequences for such organizations. Firstly, the fines are liable to be horizontal in scope and very high. In the GDPR, there are competition-level fines available now. And I would recommend you to look at the model on fines developed by German regulators, where they have deliberately developed criteria for setting fines which are set high so as to be more dissuasive. Secondly, and I think this is a very interesting development, you can have, as a remedy, enforced accountability. I hesitate. I listened to Commissioner Rohit Chopra yesterday of the FTC, who was dissenting in the Facebook settlement. And he said that fines aren't enough. And in that case, as you know, there was a $5 billion fine on Facebook. And then the year before, there was a $575 million fine on Equifax. So if we simply take a footnote from the commissioner and say, yes, fines are just one part of the armory, then another part of the armory is very interesting in that Facebook settlement and in Equifax. In Equifax, they imposed an accountability mechanism on the board. The board has to obtain an annual certification that is complying with the FTC order. In the Facebook settlement, there was an imposition of independent accountability mechanisms at all levels. At board level, a new independent privacy committee, and at operational level, compliance officers. And obviously, the way this works will depend in part on Facebook, it will depend on the detail, and it will depend an awful lot on how the FTC supervises it. But it's an interesting new element for the toolbox, the sanctions toolbox of regulators. Let's move away from the toolbox and just talk about reality. That if you talk to people who do research on corporate psychology, and if you talk to practicing lawyers, they will tell you that fines are not the only way of persuading people to be compliant. Companies can absorb high fines, but they do care about making profits, and they do care about their reputation. And if their reputation suffers, it can harm sales. And this is another of the thorns in accountability. If you're not accountable, it can have these practical consequences. And if you end up in court as a result, then it is becoming clearer and clearer that courts across the world are becoming more sensitive to enforcing privacy and data protection. In 2014, in Raleigh, in California, the US Supreme Court said privacy has a cost. In 2017, the Supreme Court in India, in Puttaswamy, said that privacy is the constitutional core of human dignity. And the court went further and it said, India has to develop a robust regime of data protection, including specifically accountability. And you will see in Section 11 of the Data Protection Bill before the Indian Parliament, accountability, a clause on accountability. And in the European Union, the case law of the Court of Justice since Google Spain in 2013 has deliberately applied the data protection rules as broadly as possible so as to ensure effective and complete protection of the persons concerned. A year ago, at the last international conference in Brussels, the president of the Court of Justice, Kern Lennertz, said that the court is very attached to high levels of accountability of controllers in light of what he termed the central theme of accountability in the GDPR. And it is worth having a look at the recent case law of the court, cases like Wirtschaftsakademie, Fashion ID, and most recently Planet 49. And you will probably see a tipping point combined with the GDPR for the present economic model of private surveillance. So let's look at the conclusions so we can get to our panel. Accountability is worldwide. It's on the move. It requires legislators to make sure that accountability is in the legislation. It requires there to be adequate tools in the sanctions toolbox. Accountability is essential for organizations. Liz Denham goes further. She doesn't think it's essential. She says it's crucial is the way she puts it, for protecting personal data in the digital age. It requires organizations to be responsible, to understand the risks their processing creates and to mitigate those risks. And it wants to the creation of data protection woven into the fabric of the organization. Accountability empowers regulators, but to benefit from it, they have work to do. They have to breathe life into what it means. And then one final point. My own view is that an accountable organization will naturally develop towards accountability 2.0, which we'll be discussing this afternoon. And 2.0 is more than avoiding risk to customers. It's responsive, creates values for individuals and society, as well as for organizations. It's transparent about what it's doing and why it's doing it, and it is also ethical, because the data controllers are relating to the data processing of their fellow human beings. Looking forward to accountability, I'd like to end this keynote by quoting Giovanni Buttarelli at the International Conference last year. Not everything that is legally compliant and technically feasible is morally sustainable. Thank you very much.